Hello everyone, thank you for joining us in our 2024 complimentary webinar series covering the FAR, or Federal Acquisition Regulations. We are coming to you live today from Washington, D.C., and we're so glad you all could make it. Okay, so a bit about this series. As usual, all of our webinars are complimentary and recorded. The FAR has 52 total parts, and we will run through them sequentially each week on Wednesdays and Fridays at noon Eastern Time. The recordings and PowerPoints will be posted within 24 hours of the webinar ending. You can find the recordings on our YouTube channel simply by subscribing to it using the link you see on the screen. There's no cost. You can find the PowerPoint on the SlideShare site using your LinkedIn credentials to log in. Again, there's no cost. We also offer sponsorship opportunities. If you are interested, please send us an email to hello@jenniferschaus.com. And now for how to sign up for this series. Unfortunately, there is no bulk registration. You must register individually for each webinar. If you go to the Jennifer Schaus website, navigate to the section called the FAR, and you'll find the individual registration links. Also, the recording links will be posted here upon the completion of each webinar. Please note that we covered the FAR in 2020, so if you are eager to get a jump start, please find these historical recordings on our site. Navigate to the Webinars tab and scroll down to the section called the FAR 2020. Because it has been 4 years, many of the regulations have been changed and updated, so please use this as a reference tool only. And now a bit about us. We work with established federal contractors worldwide, helping them to navigate the market. Our services range from market analysis reports to contract vehicles and compliance. Some of the contract vehicles we support are listed here on your screen. For more information, please visit our website. Okay, those were our services for federal contractors, but we also provide marketing and advertising services for organizations who are selling to federal contractors. We can add the extra muscle to your marketing efforts via our newsletter ads and webinar sponsorship to in-person events. Please email us and ask for a media kit. We are currently offering a discounted offer in our newsletter, which reaches over 33,000 subscribers. If you want to place an order or have any questions, please send us an email to hello@jenniferschaus.com. Contract vehicles can be great marketing tools for pursuing federal business. Current open solicitations include Navy Seaport, Next Generation, and NASA, as well as GSA Alliant. Additionally, the GSA Multiple Award Schedule is an open and rolling RFP. If you qualify for any of these and need proposal support, please email us for a quote. As you know, congressional hearings on both the House of Representatives and on the Senate side are open to the public unless otherwise stated. We have a list here of the upcoming schedule, including the date, time, building, and room numbers. Most meetings take place in the Dirksen, Rayburn, or Cannon buildings. If you are selling to any of these departments or agencies, attending the hearings can be a great way to gather information, understand the process, and also network with influencers. Please join us for these upcoming complimentary webinars with various Apex accelerators. Jennifer will be covering GSA schedules as well as federal marketing for a local Apex accelerator in Virginia. These are complimentary and online webinars, so please join us. She will also be teaching 2 classes for the Maryland Apex Accelerator, one on marketing and one on the GSA schedules. These are in July and December, and once again, complimentary. Coming up next week, we will hear from Carrie Palmatier on small business innovation and federal contracting. Specifically, Carrie will cover information on SBIRs and STTRs. These 2 options are a great way for tech companies to grow in the federal sector. This is a 2-part series, and as always, these are recorded and complimentary. Please join us and over 300 government contractors on Monday, June 24th at the Kennedy Center for our Federal Government Contractors Summer Soiree. Firstly, we want to thank our event partner BitSpeed and also our sponsors, Capital Bank, RXO, GovSpend, Federal Compass, Fully Promoted, Sandy Spring Bank, Outwork, Caltech, and Capital Bank, as well as our in-kind sponsors, the Virginia Apex Accelerator, Nova Hispanic Chamber, and ZK Development. You'll be able to meet with the federal government, including the SBA, USAID, NSF, NAVAIR, U.S. Air Force, the Army, HHS, the VA, and the Department of Education. Please register in advance to attend. Our webinars are complimentary thanks to our longtime and generous corporate and in-kind sponsors. Please allow me to introduce them. We would like to thank our friends at GovEvents, the premier platform for posting events related to government and government contracting. You can find all of our webinars and our events on govevents.com, as well as recordings from our past 600 plus webinars. We also want to thank Tom Johnson and his team at Set Aside Alert, the go-to publication for contracting opportunities for small, women-owned, veteran-owned, HubZone, and 8A firms. Visit setasidealert.com for more information. The Fairfax Economic Development Authority has an online calendar of events and webinars. We want to thank them for posting our events and webinars on their calendar. The Virginia Apex Accelerator at George Mason University offers free one-on-one counseling to established government contracting firms in Virginia on federal, state, and local procurement topics. If you are interested in learning more, please use the links provided to explore their services, review homework recommendations, register for live training, and find useful links to agencies and other self-directed learning. One-on-one counseling is limited to eligible client companies. Appointment requests are handled in the order they were received and based on counselor availability due to high demand. Online resources and group trainings are free with no restriction on business location. Join the Greater Reston Chamber of Commerce's monthly GovCon Council meeting to network with peers, learn about upcoming events and opportunities, and help to shape future programming. The meetings take place the fourth Tuesday of each month at 8:30 a.m. at the Greater Reston Chamber of Commerce. The next meeting will be on June 25th. Do you need help winning government contracts? Bitsby can help. Users can find contract opportunities from federal, state, and local government. Additionally, you can search for teaming partners, income point of contact, expiring contracts, compliance matrices, and also proposal templates. Create your login today at bitspeed.com. Bitspeed is an official partner of the U.S. Small Business Administration's E2G and Power to Go program. Events are the ultimate engagement channel to bring government and industry together. 68% of government personnel report that they attend more than one event each year. The Federal Business Council, or FBC, has worked with government and industry for 45 plus years to create gatherings where ideas are shared and to help government achieve its goals. This includes agency industry days, cybersecurity symposiums, technology expos, and offsite meetings. FBC provides full lifecycle meeting, planning, and event management. With over 5,000 meetings under their belt, FBC has the experience, systems, and personnel to make your next event exceptional. Learn more at www.fbcinc.com. Now, last but not least, please check out our friends over at GovBrew. GovBrew is the most read GovCon newsletter, keeping thousands of GovCon professionals in the loop with news, updates, and opportunities in the federal contracting market, all in a fun and accessible email that only takes 5 minutes to read. It's 100% free to join. It goes out every Monday, Wednesday, and Friday at 7 a.m., and it's filled with great content, event postings, webinars, and more. We encourage you to sign up at govbrew.co, or you can use the QR code you see on the screen. And now the reason we're here today is to cover FAR Part 43. Now let's meet today's speaker. Please welcome Tamara McNulty to the webinar. Tamara, we are so excited to have you with us today and to hear your presentation. I'll put myself on mute and turn the floor over to you. Please let me know when you are ready for your next slide.
Okay, thank you so much. Good afternoon, everybody. I am Tamara McNulty. I'm a partner at the Potomac Law Group. You can see my email address right there. That slide will come up at the end, so if you want to take a picture or screenshot of it, go ahead and do it now or do it later. I have been practicing government contracts law and construction law for the past approximately 30 years. Of course, I was 17 when I started. Anyway, I do everything from contract review and negotiation to REAs, contract disputes at claims, bid protests, and pretty much everything in between. My group at Potomac Law Group, the Government Contracts Group, is nationally Chambers rated for government contracts law. This is our second year being nationally rated, and we're very proud of that. Okay, next slide. All right, we're going to talk about FAR Part 43, contract modifications. As a GovCon/construction lawyer, obviously change orders and modifications are a big part of what I do, and we're going to go through how the federal government deals with those things here today. So here are the basics. First, there's contract modifications, and there are two types. There is unilateral. Those require only the contracting officer's signature, and bilateral modifications, which require the contracting officer and the contractor's signatures. There are change orders, which are unilateral and only are in-scope changes. And finally, we'll go over contractor notifications and forms. Next slide. So what does FAR Part 43 cover? Well, it covers in general the definitions that the government believes are important. It covers policy, In 103, it covers the types of contract modifications. In 104, notification of contract changes. Rules 105, the impact of availability of funds on contract modification. Section 103 is reserved, so they're not using it yet. Maybe they will in the future, but we'll have no need to talk about a reserve section. And then 43-107 is the contract clause itself. Next slide. In 43.2, we're going to talk about change orders in general, the authority to issue change orders, change order accounting procedures, administration procedures, and the contract clauses related to change orders. And finally, in 43.3, we'll talk about forms and the use of forms. Next slide. So in general, the scope of Part 43 applies to all federal government contractors except for contractor modifications for extraordinary relief under subpart 50.01. So if you're interested in that, you should tune in to the Part 50 when it comes up in a couple of weeks. It also covers task order and delivery orders under an IDIQ contract. That's indefinite delivery, indefinite quantity contract. And they are not considered contract modifications or changes. Because IDIQ task orders and delivery orders under IDIQ contracts are considered contracts in their own right, the government can make modifications or changes to the task orders themselves or to the delivery orders. Next slide. So this is the definition section of subpart 43.101. The first definition in this section is the administrative change. Administrative change is a unilateral change in writing that does not affect the substantive rights of the parties. For example, a change in the paying office or appropriations data, those would be administrative change. Next slide. The next definition is the effective date, and it depends on the circumstances of the change. For an amendment to a solicitation, change order, or administrative change, the effective date is the issue date. For a supplemental agreement, the date is agreed upon by the parties. For a modification confirming a notice of termination for convenience, it is the same as the effective date of the initial notice. So when you get the letter, the effective date in that letter will be the effective date of your modification confirming the termination for convenience. For a modification converting the termination for default to a termination for convenience, the effective date of the termination for default will be the effective date of the change to a termination for convenience. And finally, for a modification confirming the contracting officer's previous determination of the amount due in a settlement of a termination for convenience, it's the same as the date of the previous letter determination. Next slide. Subpart 143.102 relates to policy. Only contracting officers acting within the scope of their authority can execute contract modifications on behalf of the government. Other government personnel may not execute a contract modification, act in such a manner as to make a contractor believe that he or she has authority to bind the government, or direct or encourage a contractor to perform work that properly should be directed through a contract modification. This is basically setting out the COTR or COR problem. For those of you who are experienced government contractors with government contracts, you know that there's a contracting officer, but there's also generally either a contracting officer's technical representative or a contracting officer's representative. Those parties have no authority to execute a modification, nor do they have the authority to direct a change. Unfortunately, they often think that they do. So you have to be very mindful that if a COTR or a COR directs you to do something, you need to go through the contracting officer to get a modification if it's a change to your contract. Contract modifications should be priced before execution, but if there is no adverse effect on the government, or if a significant cost increase could result and time does not permit, At least a ceiling price shall be negotiated unless impractical. That's the policy requirement. Next slide. Subpart 43.103 relates to the types of contract modifications, and we talked about this a little before. First of all, there's a bilateral modifications, or supplemental agreements, as they're sometimes called. They must be signed by both the contracting officer and the contractor and are used to make negotiated equitable adjustments arising from a change order. They are also used to definitize letter contracts or reflect other agreements of the parties modifying the terms of the contract. For example, adding a new or updated FAR clause to your contract. Next slide. Then, as we discussed earlier, there are unilateral modifications. Unilateral modifications are signed only by the contracting officer and are used to make administrative changes. For example, a change in the contracting officer. Issue change orders, generally when the parties cannot agree on a price. Make changes authorized by clauses other than the changes clause. For example, property options or suspension of work clauses. And finally, to issue termination notices. Next slide. So the next part, 43.104, relates to notification of contract changes. If a contractor believes the government has or may affect a contract change that is not in writing, the contractor should notify the contractor as soon as possible. Your notice must be in writing so that the government can evaluate if it is really a change. The contracting officer then can confirm that it is a change, direct further performance, and plan for its funding. Countermand the alleged change, say, no, you don't have to do that. This is, for example, happens a lot when a COTR asks you to do something and you take it to the contracting officer and they say, no, don't do that. We don't want to do that as a change. Or to notify the contractor that the government believes that no change has occurred. FAR Clause 52-243-7, the notification of changes clause, incorporates the substance of FAR provision 43.107, which we'll discuss in just a minute, and generally is incorporated into any contract over $1 million. If you want to learn more about FAR Part 52-243-7, you should tune in when FAR 52 is discussed. Next slide. Subpart 43.105 deals with the availability of funds. It prohibits a contracting officer from executing a modification that causes or will cause an increase in funds without having first obtained a certification of fund availability, except for modifications to contracts that are conditioned on the availability of funds or which are necessary for normal operations. Congress previously appropriated funds to certain IDIQ contracts, contain a limitation of cost or fund clause. Certification of funds availability must be based on the negotiated price, or if the modification executed before an agreement on price, the unilateral change order, which is then turned into a bilateral, may be based on the best available estimate of cost. This particular section relates to the Anti-Deficiency Act. In general, you are not allowed to spend money that the government has not appropriated. And certain contracts will contain an availability of funds clause or a limitation of funds clause, and you must pay very important attention to those clauses when you're dealing with change orders related to your contract under contracts that contain these clauses. The Anti-Deficiency Act can be found at 31 USC 1341 at SEC. Next slide. So we discussed this 2 slides ago. This is subpart 43.107, the contract clause itself. It allows contracting officers to insert FAR clause 52-243-7, notification of changes in certain contracts, primarily in negotiated research and development contracts and supply contracts for the acquisition of major weapon systems or principal subsystems. FAR 52-243-7 may not be used in contracts expected to be less than $1 million unless the contracting officer anticipates that situations may arise where the contractor may allege the government has effected changes other than those identified as such in writing and signed by the contracting officer. One of the examples of this can be what I like to call the death by 1,000 cuts, when a number of change orders add up to be bigger than the cost of each individual change in and of itself. Next slide. So now we move on to the part two. So subpart 43-201 is the general about change orders. Nearly all government contracts include a changes clause that permits the contracting officer to make unilateral changes in designated areas within the general scope of the contract by issuing a written change order on standard form SF30, which is called the amendment of solicitation slash modification of contract, unless it's otherwise provided. Next slide. In that case, the contractor must continue performance of the contract as changed. But as we just talked about before, with regard to the Anti-Deficiency Act, the contractor is not obligated to incur costs beyond the limits stated in the limitation of cost or limitation of fund clauses if the contract is a cost reimbursement or is incrementally funded. And you really need to keep careful track of whether or not the limitation of funds is reached or close to being reached, and provide proper notices under those clauses saying, okay, we're at 75%, we're required to notify you that with these changes, we're going to reach 75% of the limitation of funds. And once we run out, we cannot do any more work, and then you do not do any more work. The contracting officer may issue a change order by electronic means without an SF30 if unusual or urgent circumstances have arisen. Next slide. So what do the FAR changes clauses at FAR 52-243-1 through FAR 52-243-5 allow the contracting officer to do? Well, depending on the type of contract, the contracting officer may, at any time, by written order, make changes within the general scope of the contract in drawings, designs, specifications, methods of shipping or packing, the place of delivery, the place of inspection, or the place of acceptance, description of the services, the time of performance, well, which includes days or holidays or hours or substantial completion, for example, the place of performance of the contract, the place of origin, the tonnage to be shipped, the amount of government furnished property, the method or manner of performance of the work. This one you want to keep careful eye on, because if they change your method or manner, you may have a claim for a change based on a change to your means or methods. What do I mean by this? For example, I had a client who was working in South Sudan, and at the start of the pandemic, they were ordered by the contracting officer to cease performance, but they were also ordered by the contracting officer to not send our employees home, which meant we needed to keep paying not only their salaries, but also their living expenses and their security and the like. That was a change in the means and the methods of performance for which we requested a change. That change was granted because they did order us to change our means and methods of performance. Finally, directing acceleration in the performance of the work. Next slide. So what, if any, changes clause increase or decrease in the estimated cost of or the time required for the performance of any part of the work? Well, then the contracting officer shall make an equitable adjustment in the estimated cost, the delivery or the completion schedule, or both. the amount of any fixed fee, the ceiling price, hourly rates, and other affected terms. Next slide. And the contracting officer shall modify the contract accordingly. Generally, requests for equitable adjustment must be submitted within 30 days of the change. You'll want to see your specific changes clause in your contract. If no agreement on the request for equitable adjustment, the contractor may file a claim under the Contracts Disputes Act clause and under the Contracts Disputes Act. Next slide. Subpart 43.202 regards the authority to issue change orders. Change orders, again, must be issued by the contracting officer, except when authority is delegated to an administrative contracting officer. Administrative contracting officers generally are the ones who have some authority over multiple contracts across agencies. For example, in the case of approving a novation or a change of name of the contractor, if you are concerned that your contracting officer or your administrative contracting officer is exceeding their authority, what you should do is ask to see their warrant. The warrant provides each contracting officer with their particular scope of authority, generally what they can change and how much authority do they have in terms of cost. They should give that to you. COTRs and CORs will not have a warrant that allows them to make modifications to their contracts. Next slide. Subpart 43.203. This is regarding change order accounting procedures. It requires contracting officers to advise contractors of the possible need to revise their accounting procedures to segregate costs associated with the change. In fact, segregating your costs associated with the change is just good standard practice to begin with. Set up new cost codes for change orders. Segregable costs include non-recurring costs, for example, engineering costs, costs of obsolete or reperformed work. Also can include costs of added distinct work caused by the change order, for example, new subcontract work, or new prototypes, new retrofit or backfit kits. And finally, costs of recurring work, for example, labor and material costs. Unfortunately, there's no provision for what happens if the contractor cannot segregate such costs. You should try, as I said, the best practice is to segregate your cost as a matter of course when you have change order work. Next slide. Subpart 43.204 relates to the administration of change orders. Change order documentation. So if a change orders are not forward priced, two documents are required. A change order and a supplemental agreement reflecting the equitable adjustment. Change order documentation, administrative and unilateral changes initially require only the change order. However, when you finally reach a bilateral change order, you'll have to document that in a bilateral change, which is also called a supplemental agreement. Next slide. The administration section also talks about definitization. Equitable adjustments should be negotiated in the shortest possible time. It requires a contracting officer to, among other things, establish suspense systems, perform cost analysis, lists of significant contracts events to aid in review of requests for the request for equitable adjustment. Administrative contracting officers must seek contracting officer concurrence before adjusting the contract delivery schedule. They do not need to seek contracting officer concurrence for other items that we discussed earlier that they are allowed to do under their administrative contracting officer warrant. Next slide. Finally, in administration, complete and final equitable adjustments. Contracting officers should ensure that all elements of the equitable adjustment have been presented and resolved prior to a final equitable adjustment, and include in the supplemental agreement a release from the contractor. The release language that is recommended to avoid subsequent controversy is, in consideration of the modifications agreed to herein as complete and equitable adjustments for the contractors, and then you describe the proposal for adjustment, the contractor hereby releases the government from any and all liability under this contract for further equitable adjustments attributable to such facts or circumstances giving rise to the proposal for adjustments, except for, and that except for is where you'd put in, you're starting to believe that you're having a death by 1,000 cut situation. This is where you're going to want to insert that language. It says the cumulative impact of all the change orders on this project, or whatever the change orders are that you believe are going to start indicating a bigger cost because of so many changes. So that's the language that is recommended. Next slide. So briefly, we're going to discuss 43.2.05, which are the contract clauses relating to changes. There are specific FAR clauses and alternates for different types of contracts. So FAR Part 52.243-1 relates to fixed price contracts and has several alternate clauses therein, depending on the kind of fixed price contract. 52.243-2 is for cost reimbursement contracts, also has several alternatives. FAR 52.243 are for time and materials or labor hour contracts. 52.243-4 are for construction contracts. 52.243-5 are for construction contracts under the simplified acquisition threshold, which is generally $250,000. And finally, FAR 52.243-6 requires the contractor to segregate costs related to changes used in contracts of significant technical complexity if numerous changes are anticipated or if deemed appropriate by the contracting officer. Next slide. So 43.301 relates to the use of the form. The form SF30 must be used for any amendment to a solicitation, change orders issued under a contract's changes clause, any other unilateral contract modification issued under a contract clause authorizing such modification without the consent of the contractor, for example, when you can't agree on the price, administrative changes to the contract, supplemental agreements, removal, reinstatement, or addition of funds to a contract. That's when the SF30 must be used. Next slide. The SF30 may be used for modifications that change the price of contracts for the acquisition of petroleum as a result of an economic price adjustment. For example, high gas prices after the pandemic was over, or lower gas prices when the pandemic began and no one was driving. Termination notices, you may use the SF30. And finally, certain purchase order modification. Next slide. So to summarize, contract changes can be made through formal modifications or through change orders if within the general scope of the contract. Contracting officers must comply with the requirements of FAR Part 43 when issuing modifications or change orders. If a modification or change order increases in price, the contract increases the price, the contractor should promptly file a request for equitable adjustment in writing within the time frame specified in your contract. If a modification or change causes a decrease in price, the contracting officer will generally calculate the decrease or negotiate with the contractor to reach an agreement on the negotiated decrease in the contract price. If the contracting officer and the contractor cannot agree on the equitable adjustment, the contractor may file a formal claim under the disputes clause, which is in FAR Part provision 33.215, and in clause 52-233-1, and these relate to the Contracts Disputes Act. Next slide. So I think we've done this in record time. I really want to thank everybody for listening in. And if you have any questions, feel free to contact me. My email address is right there. If you have any questions on anything else related to government contracting, feel free to contact me at my email. You can find me on LinkedIn. You can find me at our website, which is www.potomaclaw.com. Thanks again. I really appreciated your time today.
Thank you, Tamara, for such an informative presentation, and thanks to everyone who joined us today. As usual, you can always catch the recording on our YouTube channel within 24 hours. Thank you again for joining us, Tamara, and everyone else. We hope to see you on Monday for our event, or next week for FAR Part 44 and FAR Part 45. Thank you.